Praise our living God. Salute sana kwa wale mafollowers wangu ambao wananifuatilia, na washukuru sana katika jina la Yesu Kristo. Unafanya hilo tendo la imani kwa kusubscribe kwa YouTube channel na kucomment. That is good. Naomba ya kwamba kusubscribe kwako na kucomment kusiwe kwa bure, bali Mungu akakukumbuke. Kwa hivyo tunaendelea na kusikiza, tuko kotini tunasikiza. And the beautiful thing that I have heard is that unaposikiza vizuri majaji wa Supreme Court wanapo maswali yao wanavoulizia, then utakuja kurealize, ukifungua jicho lako la ndani, utakuja kurealize that God is in control, na Mungu huyu ambaye huwa tunamtukuza na tunamuomba atupe amani katika taifa la Kenya, kwa kweli anaenda kutupa amani na kutupa justice kupitia kwa Supreme Court. Acha tu tuende comment section. Naomba tu comment hapo, tuombee majudges wetu na tuweke tu comment, may justice prevail in Jesus name. May justice prevail in Jesus name. Alafu naomba kama haujatazama maswali ambao majudges wameuliza, na kama haujaona katika vyombo vingine vya habari, nimeona sio vizuri, nataka niwaletee hapa. Sio vizuri muyaangalie tu upande mwingine mkose kuelewa. Pia lazima tuone neema ya Mungu katikati ya hawa majudges. Ndo maana nawaambia, naomba tu utazame tu pole tu haya maswali, na utaona ya kwamba neema ya Mungu ipo juu ya hawa majudges, and God is in control. Sikiza tu vizuri, nimewaletea hii video clear ili muelewe na muisikize. Alafu baada ya kuisikiza, listen very carefully. Baada ya kuisikiza, naomba tu Mungu anapowasaidia hawa majudges kuprevail, justice ionekane. Naomba pia justice ifanyike katika maisha yako. Sasa tufuatilie tu tusikize, then you just unajua we are preaching peace, na haya maneno ambayo tunafanya hapa hivi sio ya mchezo. Mwisho utaona ya kwamba Kenya kumekuwa na amani kwa sababu ya mimi na wewe kushikana, japo ya kwamba hatujuani na hatufahamiani. Tuende pale comment section. Tunapoendelea kusikiza, sikiza vizuri.
Thank you very much. It is now time for the judges to ask any questions or clarifications in regard to the submissions we have had today. We expect the answers when you will be making a rejoinder. We are not expecting the answers now. It's when you're making the rejoinder. I will start with the Honorable Justice Oko.
Thank you, Judge President. I have three very short clarifications that I want to seek from the team representing the first petitioner. The first one, perhaps I can direct it directly to Senior Counsel James Orengo. What is the relevance of rejected votes when computing the results or the outcome of a vote? The relevance of rejected votes. The second one, I would have addressed it to Ms. Soweto, but the team can deal with it, and you are not answering us today. The postponement of elections in certain areas, and you say this resulted in voter suppression. That people wake up one morning to go and vote for a particular category of candidates, that I go to the voting or polling station to vote for an MC or is it called MC? That people go to vote for a senator but not the other positions. Do we have any scientific nexus on this, or is it just an assumption that this happens? The last question for me is on the reliefs that most of the petitioners have sought. We were addressed by Senior Counsel Feroz Noroji and also Senior Counsel Professor Jenda on the reliefs or the relief in Section 80, subsection 4. And I'm wondering, what are some of the elements that must be satisfied before the court can act or can grant the relief under Section 80, subsection 4? That would be all from me, my lady.
Thank you. Justice Renara.
Thank you very much, Chief Justice. Thank you, Counsel. You've been most helpful to us, particularly to myself. I have 3 questions, 4, I think, very short ones. The first is to Senior Counsel Philip Murger. You addressed us on the PDF format of the forms, but in the pleadings, there is a JPEG question. Would you like to?
I would like to immediately correct that. It should be JPEG, not PDF.
Oh, okay. So it was JPEG. It was JPEG.
JPEG to CSV.
Okay. Would you then like to connect, because you addressed us, I think you didn't connect the JPEG to PDF and then you said CDF?
I will, but I'd just like to clarify that that was a mistake.
Okay. All right. But just clarify when you answer so that we can get it right. And also in the context of the staging and tampering and so on, explain to us how that happens in real time. Give us, say, Kagera Primary School Form 34A. What exactly happened in your theory, because you say some of these things you don't have? How was Kagera Primary School interfered with the Form 34A? Number 2, Mr. Arua, and this could also go to the other counsel appearing for the commissioners. You've raised many issues going way back before the election. The Venezuelans, mistreatment by the chairman, we're not allowed to do this and that. But we saw your clans in public reading out results. And that's what I'm calling my acquiescence question. They did all these things until the 11th hour. What evidence do we have that it's not an afterthought, that they're not doing this in good faith? What evidence do we have, apart from the question of the instructions to counsel, the meeting they called? Why do we have anything showing that for the last 3-4 months they documented these grievances and that there was therefore a storm brewing? My own sense of things is that when you come only at the point of final declaration, how then do we trust that in fact there were issues before? Tied to that, what role did violence play at Bomas? Because we have the evidence of the chairman that I couldn't do this because I was attacked, Gulia was attacked, we couldn't announce 27 polling station results, constituency results. What role did violence play at Bomas? I think you need to explain that as the commission, which is what you've said. For Feroz Noroji, Regulation 87.3 You've asked us to declare it unconstitutional, declare it inoperative. Please address that issue in the context of retroactivity and retrospectivity. At the time these things were happening, it was the law. You're telling us to now declare it unconstitutional. What happens to events? And you know what I'm asking about this. Mr. Ndegwa, you made a very innovative, I must say, submission regarding the diaspora vote, the number of constituencies. In answering my question, please go back to Article 89.1. 89.1 says there shall be 290 constituencies for the purposes of the election of the members of the National Assembly. We are addressing a vote in a presidential election. Please connect 89.1 with the presidential election. Otherwise, the way you left it hanging, someone would ask the question, what has this got to do with this court and the petition before us? I thank you, CJ. I thank you, Council.
Yes, let me just take up from where Justice Lenaula has with Mr. Ndwiga. Mr. Ndwiga, if you look at Article 38(2), every citizen has a right to participate in elections. How then do you reconcile that with your argument on Article 89? Because constituencies don't vote, citizens do. So again, prisoners, persons in the diaspora, how are they to be provided for if we are to follow your line of argument? My next question was to Philip Murgo. I was drawing a chart when you explained to us that what you're telling us is that in the evidence that you have is that the Form 34 went into the Kim's kit at the polling station to the constituency. Then between the constituency and the public portal, the Form 38's numbers were changed. They were changed in that sequence, if I'm to understand you. Now, I don't understand much about ICT, but I presume that at the polling station, when the Kim's kit takes the image, these forms are written in handwriting. How can you explain then, so that I can understand, how a form can be changed in handwriting? This is not typing, it's in handwriting. All these forms are being uploaded and changed, different people's handwritings. How does that happen? For Ms. Soweto, she's not here, but since we'll answer later, I was curious about the issue of voter repression and her arguments on that. If we look at the Constitution, Articles 136, 177, 180, each of these elections are separately provided for. So you have the presidential election, which has its qualifications, nomination process, even the dispute resolution process of a presidential election is separate, the governor is separate, the member of parliament is separate, the MCA is separate. And what happens when a voter goes to vote, they get 6 ballots. So it's 6 ballots into 6 ballot boxes. What we have then is 6 different elections, but on the same day. So if your argument is voter repression, then is the voter repression only to the presidential election? Or is that an argument that can be used by an MCA in Kakamega County to say that because the gubernatorial elections were cancelled on that day, my MCA votes have also been affected? Or, I mean, is it just the presidential election that the voter suppression argument is standing for? Or is it all? Because they're all separate elections. So how does one election affect the other? I think those are my questions for now. Thank you.
Thank you. Thank you, Chief Justice. Just a few questions. I think this could go to, Mr. Orengo. You started us off with this elephant in the room, this 50% plus 1. And I've read the submissions, I've read the affidavits. There is something still surrounding this question of voter turnout, the percentage. It's like the beginning of where the controversy is located. What is the relevance of the percentage of voter turnout to determining whether a candidate marshaled the magical number? And then back to Mr. Murgor, this staging. Again, I've been intrigued. I've been reading. If I understood you correctly, and if I understand the affidavits correctly, we are having this Form 34A. The original, which is filled, leaves the polling station to go to the National Talent Center by road, let's say, for ease of understanding. Its image leaves to go to the same destination, but this time by air. Somewhere along the line, in mid-air, the image is captured. And then all sorts of things are done before it is re-uploaded. Which means, therefore, if you go to that captured image, which has been re-uploaded, you will find different content from what it had at the polling station. So, to determine whether that has actually taken place, you would have to go now to the tallying center and locate that one that left by road and compare. Is it possible that that capturing in mid-air also somehow magically changes the content of the one that left by road? Okay, just because I just want to understand. Then let's get back to the 4 commissioners, because this is serious. We were informed by, I think this must have been Mr. Nyamodi, quite graphically, that the 4 commissioners were allocated roles other than those for which they were appointed as commissioners. Some were heads of protocol, I think others were media, welfare. Interesting stuff here, allocating such roles to commissioners. Why didn't they protest? Is this chairperson we are dealing with such a terror that nobody can face him and tell him you can't do this? Because now what we are hearing, these are serious disclosures. Because you can imagine I being, but because I was annoyed by, not annoyed, upset by my friend Willis for having tried to compare. So I'm just wondering, why is it that very serious Kenyans did not seize that chance and protest to the Kenyan people that what we are being given, the roles we are being assigned, have nothing to do with tallying and verification and carrying out our constitutional mandate. I think this is tied to my colleague here, is why to the tail end? Because I'm sure the voter out there also wants to know. So let me leave it at that.
Thank you, Honorable President. I have a few questions, and the first one would refer to the lead petitioner, or rather the main petitioner, the first petitioner, if I may say, in the lead file, which actually initially was petition number 5, E005, Raila Odinga and Martha Karua versus the respondents. And later on, after consolidation, it became the lead file and file number 1. I'm concerned with the reliefs that are sought, the alternative relief sought. The first relief relates to the issue of scrutiny, which is ongoing, and the issue of the threshold, constitutional threshold of 50+1. And after the inquiry, you would like that after the scrutiny, election, and the inquiry on the election technology, all the claims which have been made, and that after there should be nullification of the results, and then an exercise of recount, and after the recount and tally, that the chair be directed to declare the petitioners as the petitioners, that's the two petitioners, Raila and Martha Karua, to be the successful, or to be the winners of the elections. That's one of the. So I was saying that we would like you to lay a basis, legal basis for this in your rejoinder. No remedy that has been pleaded is going to be taken casually. Every pleading, every relief that we have sought, we are taking it seriously as a court. Therefore, because you will not just do it cosmetically, you must be meaning it. So, is this doable? Is this feasible in law and in all other practical ways? We want justification, and from, I think even suggestions were there in 2017, but now we are here. So I would like you to firm up that and give us justify the legal basis, the constitutional basis of that, and whether lawfully, constitutionally, that is possible. Of course, we'll be coming to the issue of the capacity, after all the allegations, the capacity of that chair carrying out to be in charge of the exercise of the next process, if you are successful. But before that, okay, there's the alternative that if that's not workable, then a fresh elections take place. Now, that's the problem I'm having is that, and if an election is to be ordered to be done now, yet one of the reliefs you are seeking is that the chair and substantially the commission, but effectively the chair, you want us to hold him or to declare that he is not fit to hold public office because of his malfeasance, because of his the illegalities, irregularities, even allegations of fraud that he has perpetrated, that is not fit to carry out that exercise, to be in charge of such elections. Our Constitution, I believe, has never contemplated and envisaged such a serious situation, such a lacuna. And you know, we are all peaceful, loving people. We believe in the rule of law. We believe in constitutionalism. How is that possible? What are your proposals practically on the ground? If suppose this was done, how do you want us to navigate and apply the law? Is that possible within the law? These are serious issues. These are serious remedies you're asking for. In the meantime, what is the de facto state? What is the status quo? Is that underpinned under the law? These are the questions that we would like to ask, because as you know, in Kenya we have never had a state of emergency, and we all never contemplated, and I don't wish to think about it. Finally, yeah, actually that is all, because the other questions have been asked quite exhaustively by my colleagues. Thank you.
Thank you, Judge President. The challenge one faces when they talk about the same subject at the end of a conversation by many people is that they find themselves repeating issues. But I will still ask what I had noted down during the proceedings, and you can choose the manner in which you will answer them. For Tim Orengo, my concern is And actually for everyone who has spoken about the commission, what we have heard is what, about this commission, is what some time back we had someone describing, was it an accident or something on TV, and we were told it looked like a video and drama. At least that's how I perceived the submissions on the commission. And so my concern is, when did this commission become this dysfunctional? The effect of becoming that dysfunctional? What corrective measures were attempted, if any, and with what result? My second concern is from 34A. Minor Kia told us that this election is done not at Bomas, but at the polling station. And for the presidential election, the return of that form is first by electronic transmission. And so, the way I understand it is that a photo would be taken of the form at the polling station. A photo. I want you to tell me whether it's called a photo or what it is called. Is it called a photo? Is it called an image? Is it called what? That's the question I'm asking. And so that time when it is taken, and as it is being sent originally, is it in PDF form? So the journey, because this has to be understood, the journey from the polling station to Bomas, the things that happen in between must be described by the nature of that image at the original place, at the starting point. My other concern, which ought to have followed the first one before this PDF language, is what is to be done as a corrective measure against the chair of this dysfunctional commission. And is it to ignore the constitutional procedures and safeguards that are already in place? My final concern is concerning the relief to declare. What I have heard since morning, because of the dysfunctionality of the commission and a few other things, is that nearly everything about Articles 81, 86, the Act, have been impugned. In fact, one of you told us that everything that would possibly go wrong went wrong. So if every process that was undertaken in this process has so far been impugned, are we nevertheless to declare a winner? Are the figures in the event that we arrive at figures that show that either the current president-elect has more votes than others, and or the petitioner in petition number 5 in fact has more numbers, what are we to do? Are we still to declare? Irrespective of all the other processes having been impugned as you have submitted to us today. If you assist me with some direction in those issues, I shall be in a position to deal with the petitioner's case. We'll see what we will do with the respondents when their time comes. Thank you, Judge President.
Thank you. I think all the questions I had have been asked, but I'd just like to follow up on what Justice Ibrahim asked. The team on the Reid petition, they have been called Team Senior Counsel Orengo. You have asked us to find the chairman culpable of various breaches of the Constitution. And as Judge Ibrahim explained, you have even told us to find that he cannot. Should we find that there should be a repeat election, he cannot preside. My dilemma is, this is a constitutional office order, under Article 251(2) of the Constitution, there is a detailed procedure that is provided for the removal of a constitutional office order. And what I would like you to address us is, how do we go about that? Would we be making an order that is contrary to the Constitution? Because like the judge was explaining, we are a country that believes in the rule of law, in the right of a person to have a reply, to be tried. So, you know, for the breaches that EOC has committed. And that is also related to the issues you have also cited about criminal culpability. I want you to address us on, because we have an Election Offences Act, so that if somebody has committed an election offense, they ought to have been charged and tried before the court with the jurisdiction. In this case, I know we gazetted some magistrates to deal with election offenses, and my question is whether we wouldn't be usurping the powers of the magistrates if we have to make any order regarding election offenses. Then to the team led by Senior Counsel Mr. Mwite for the 4 commissioners, I still want to understand at what point the commission ceased to function as a corporate entity. Is it when the 27 constituencies were not announced? Or is it when, I am really trying to understand that, because we saw them announce regularly the results at the plenary in Bomas. We really want to understand, like the Vice President is asking, when did the commission become so dysfunctional? we really want to understand that. Is there a stage where they were working together in tallying and verifying, and then they went and announced, and then suddenly there was a stoppage because the announcements also stopped streaming live? So we really want to understand that. Then my last clarification will go to Mr. Kibe Mungai. And I want you to answer this and tell us how you know that IEBC did not make arrangements for certain categories of people to vote, especially the IEBC staff. How do you know they did not vote first before they started the exercise? Because they were in a polling station, they could have transferred their vote to the station where they were conducting the exercise and voted. You know, because this seems quite subjective, so you needed to explain more that you know 700,000 people did not vote because IEBC did not make arrangements. I think those will be my questions or clarifications that I will be seeking from Council.
Justice, I have one follow-up. May I piggyback on your last question? Section 6 of the IEBC Act, 6.1, says that the chairperson of the commission shall be a person who is qualified to hold the office of judge of the Supreme Court under the Constitution. Then 7A says that the chairperson or member of the commission the office shall become vacant if the holder dies, resigns from office by notice writing to the president, or is removed from office under Chapter 6 or Article 251. In that context, if perchance we were to order removal of Chebukati as chairman, would the commission still be intact with the remaining 6 commissioners without a chairman of that qualification? I'm just wondering for my own sake. Thank you very much, Chief Justice.
I think that brings us to the end of today's proceedings. It was a long day.
Kind permission, Madam Chief Justice. There is still an issue arising out of the scrutiny. I am told I would like my learned junior to explain, because he's the one covering the technical issue of the scrutiny.
Good evening, my lady, the Chief Justice, and the Honorable Judges of the Supreme Court. My name is Eric Gumbo. We've had interaction with my colleagues who are handling the scrutiny, and they give us the indication that there's been very good progress so far. But there's one specific issue which they would want to get clarification from this court on, that arises from Order Number 2. Specifically, the use of the word forensic image. Now, the applicants appear to be interpreting that to mean an opportunity to get the image of the entire server. Now, that is causing a bit of a concern, because then it means if they have the image of a server, technically they'll have gotten access to everything that certainly is contained in that server. It means that that order will be so far-reaching that after that event, it may not be possible for the IEBC to use that server again. It then particularly concerns the Commission, because